Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Getting a family court case dismissed is something many people hope for, but it's important to understand it rarely happens the way it does on TV. A dismissal means the court is throwing the case out, ending it before a final judgment. This is uncommon because courts prefer to resolve disputes, but it is possible under specific circumstances. The most straightforward way a case gets dismissed is through a voluntary dismissal. This happens when the person who originally filed the case, known as the petitioner, decides to withdraw it. They might do this if they've reconciled with their partner, reached a private agreement, or simply changed their mind. They file a specific form with the court, and if the other party agrees, the case is closed. However, you're probably wondering how to get a case dismissed when you're the one being sued, the respondent. This is called an involuntary dismissal, and it's much harder. You can't just ask a judge to dismiss a case because you don't like it. You need a strong legal reason, which is usually presented in a formal motion to dismiss. There are a few key arguments you can make. First, lack of jurisdiction. This is a powerful argument. It means the court in that specific location doesn't have the legal authority to decide your case. For example, if a custody case is filed in California but the children have lived their entire lives in Texas and have no connection to California, the California court may lack jurisdiction. Another reason is improper service. Every state has strict rules about how a person must be officially notified that they're being sued. This is called service of process. If the other party didn't follow these rules perfectly, you can ask for a dismissal. Be aware, though, this is often a temporary victory. The judge will likely just dismiss the case without prejudice, meaning the petitioner can fix the mistake and serve you correctly, starting the case all over again. A third, more technical reason is failure to state a claim upon which relief can be granted. This basically means that even if everything the petitioner wrote in their court papers is true, there's no legal basis for their request. For instance, if someone filed for child support for a dog, a court would dismiss it because the law doesn't provide for that. While not technically a dismissal, reaching a full settlement also ends the case. You and the other party negotiate an agreement, put it in writing, and have the judge sign it as a final order. The case is then closed. Ultimately, trying to get a case dismissed on a technicality can be a complex and expensive strategy. It's crucial to remember that this information is for educational purposes only and is not legal advice. The best first step is always to consult with a qualified family law attorney in your state who can review the specific facts of your case and advise you on the best path forward. Thank you so much for watching. If you found this information helpful, please give this video a thumbs